To understand the Constitution, one must be aware of the nature of American civil government. And to understand the nature of American civil government, one must be familiar with its origins, know the principles that served as the basis of the Constitution as it was written, as well as its overall purpose. One must be aware of the explanation of various clauses during the state ratifying conventions, and comprehend the difference between a federal and national system. This first video is on the origins of the U.S. Constitution. First, it is no coincidence that the founding of the colonies in British North America occurred after the series of events known as the Reformation. Providentially, most of what is the United States today was virtually left untouched by European powers until the conclusion of that historical event. The biblical precepts of the Reformation era greatly impacted, influenced, and shaped the development of civil government in British North America, beginning with the first settlements in the early 1600s all the way to the creation and ratification of the Constitution in 1789. The origins of American legal and civil jurisprudence, of course, goes back much further. A strong claim has been made and supported by the author of the book, The Making of America, The Substance and Meaning of the Constitution, that the Bible, ancient Israel, and the Anglo-Saxons of the 5th to 11th centuries played a significant role in shaping the founders' thoughts on civil government during the last half of the 18th century. Other sources of influence include ancient Rome, the Magna Carta, the Reformation as mentioned earlier, the English Bill of Rights, various colonial founding charters, the numerous experiments of colonial self-government, the House of Burgesses, the Mayflower Compact, Connecticut's Fundamental Orders, the New England Confederation, the Albany Plan of Union, the experiences under British rule during the 1760s and 1770s, the Stamp Act Congress, the First and Second Continental Congresses, various actors of the Enlightenment, such as Thomas Hobbes, John Locke, Montesquieu, British legal scholar William Blackstone, and of course, the Declaration of Independence, and the experience under the Articles of Confederation. I'm sure this list could be much longer, but the point has been made that America's legal and political jurisprudence has a rich and varied background. At the Constitutional Convention, Benjamin Franklin stated, "We have gone back to ancient history for models of government and examined the different forms of those republics. And we have viewed modern states all around Europe." Just what specific sources did the founders tap? David Limbaugh, author of the book Persecution, explains that a group of contemporary political scientists conducted a 10-year study examining over 15,000 political writings of the founding era to answer that question. The research revealed the most frequently cited authorities of the 180 names examined were Montesquieu, Blackstone, Hume, Plutarch, Beccaria, Cato, de Lolme, and Pufendorf. Although these writers profoundly influenced the founders' thinking and writings, the research concluded that the founders cited Scripture 4 times more than Montesquieu or Blackstone, and 12 times more than Locke. Indeed, 34% of the direct source quotations were from the Bible. In addition to specific sources, experience played a significant role in shaping American civil government, specifically the federal government as portrayed by the Constitution. The American Revolution, the 13 colonies' decision to secede from the British Empire and declare themselves independent nation-states, centered on the issue of sovereignty and constitutionalism. The British claimed absolute authority over the 13 colonies, while the colonies argued sovereignty was divided. The king had authority over inter-imperial matters, but the colonies had sovereignty over internal matters. The two parties could not reconcile this difference. When the Stamp Act was repealed, the British Parliament passed the Declaratory Act at the same time. This act expressly stated that Parliament can legislate for the colonies in all cases whatsoever. The reason the Declaratory Act was issued at the same time was because of the nature of the British Constitution. It was not a written document. Although it included some written documents, it was based on tradition and precedent. In order to avoid setting a precedent that only the colonies had the authority to legislate on colonial matters, the Declaratory Act was passed. The numerous conflicts the people of the colonies had with Britain, the differences in their political ideology, and the exercising of these differences by the British led to the American Revolution. For the British, it was a war for empire. For American colonists, it was a war for self-government. The American Revolution was a fight for self-government. The colonists wanted to make their own decisions without outside interference. It was not just about no taxation without representation, that only one's own colonial legislature could legitimately tax colonists. That was only one subset of the principle of self-government. The people of the colonies wanted to make their own decisions across the board dealing with internal affairs. With that fact in mind, think about the federal government's intended relationship with the states. Just as colonies wanted self-government from the British, the states wanted self-government from the federal government. There is no point for the colonies, the states, to fight for self-government from the large and intrusive British government, only to turn around and establish a new big government that will interfere with them in a similar way. Understanding this aspect of U.S. history is necessary to understanding the Constitution and thus the nature of American civil government. The Declaration of Independence and the Articles of Confederation also shed light on the nature of American government. Before we address the Declaration of Independence, let's take a moment to highlight a fallacy presented in many U.S. history textbooks. The Continental Congress was the United States' first national government. This is incorrect, because neither of the Continental Congresses had any authority to impose its will on the colonies or states. It could only make recommendations, suggestions. It could implore or encourage a certain course of action, but it could not demand individual colonies and later states to do anything. The state representatives in the Continental Congresses were akin to ambassadors, much like those of the Congress of Vienna in 1814 to 1815. The Congress of Vienna had no authority to force participating nation-states to do anything. The Declaration of Independence, though containing no real authority, expresses the political ideology the states were fighting for and an ideology that influenced the design of the future Constitution. The principles expressed include: all men are created equal. God is the source of rights, and rights are inalienable. They cannot be separated. The purpose of government is to secure, to protect these rights. Government's authority comes from the consent of the governed, and revolution is justified if government fails to protect rights, which can happen one of two ways. First, government is too weak to protect rights from others, or second, instead of protecting rights, government itself violates them. Let's elaborate on the phrase, all men are created equal, and the statement referring to God as the source of our rights. It was accepted by most at that time that man was created in God's image. Being created in God's image meant, among other things, that people have inherent worth and dignity. As for our rights being endowed by our Creator, it implies that God is the ultimate source of authority and that no human being is above His ethical law, such as those found in the Ten Commandments. And so, all men are created equal in the sense that God's law applies equally to everyone, and all people have inherent worth and dignity. Next, let's elaborate on what was meant by the phrase, consent of the governed. To consent is to concede, to allow, to grant. One cannot allow or grant someone the authority to do something unless they themselves, as individuals, already possess that authority. Thus, when expressing that government gets their just powers from the consent of the governed, it is important to understand that, in the words of John Locke, the people cannot delegate to their government the power to do anything except that which they have the lawful right to do themselves. Meaning, if I don't have the authority to do X, then I cannot delegate that authority to governing officials. The same moral law that restricts individuals restricts those in government. Another fact that must be understood in order to have a holistic, complete view of the nature of the Union, of the Constitution that was ratified in 1789, is that when each of the 13 colonies declared independence, one nation was not created, but rather 13 independent sovereign nations. In the same sense that France, Spain, and Portugal were nations, so were Massachusetts, Pennsylvania, Virginia, Georgia, and the rest of the 13. And when the Revolutionary War ended, the British recognized the independence not of one nation, but the independence of each specific individual nation-state in the same mold as England itself. The independence of 13 new sovereign states as the nations were recognized. Finally, the experience under the Articles of Confederation played a role in shaping the Second Constitution of the United States. Under the Articles, the states entered into a firm league of friendship with each other, clearly because of their shared fear of Britain. They entered into this firm league of friendship for their common defense, the security of their liberties, and their mutual and general welfare, binding themselves to assist each other against all forces offered to or attacks made upon them or any of them on account of religion, sovereignty, trade, or any other pretense whatever. Under this Constitution, the states retained nearly, if not all, of their sovereignty. In time, it was decided by enough people that the Articles were too weak and the threat of physical conflict among the states was too high, as well as the threat of a popular uprising and the desire for certain factions to use government to enrich themselves at the expense of others. These fears and the alleged weaknesses of the Articles that were blamed for these fears led to the Constitutional Convention in 1787 and the decision to scrap the Articles and create a new Constitution that would be stronger and more centralized, relatively speaking, than the Articles. Clearly, a lot of history, a lot of past experiences went into shaping the Constitution that was drafted in 1787. Just as influential, however, were the principles that shaped the new government. These principles, as well as various pragmatic decisions that made a union of the states possible, will be discussed in the next video. The creation of the Second United States Constitution.